Welcome to the Fringe News with Reverend Jeff. Tonight's episode may be a lot for some Bigfooters to handle, but the time has come for the issue to be discussed. In March of this year, there was a lawsuit filed on the very subject of Bigfoot evidence. Everyone should remember the creature suit picture that was released by Melissa Hovey and the American Bigfoot Society. But what many people don't know are the underhanded dealings that went along with it. It seems Melissa Hovey had applied for a copyright for the image that, after the facts of the case had been rendered, she in fact never owned the rights to in the first place. I'm going to take the time out to lay out exactly what happened for the community so it's educated in the facts of the case and not just the spin that the losing party may try to release. Now, it is no secret that the defendant and I are close friends and that I have no love lost from Melissa Hovey due to her own actions. However, I'm going to stick to the facts in this case to avoid putting a target on my back. Starting back in May of this year, the BigfooteryInquirer.wordpress.com started featuring the court documents and the steps in which the case is followed. Here's what the Bigfootery Inquirer had to say at the opening of the case. Plaintiff demands trial by jury. Some background information. Hovey claims to have received a picture years ago. Others also received it. Hovey issued an ultimatum to the picture taker and eventually published it with a copyright to the American Bigfoot Society. Phil Poling had made a parody video and post on YouTube panning the picture and the whole copyright strategy. Others also published the photo, which is widely panned all over Facebook and YouTube. Hovey threatens Poling and then blacklists the entire group of Teen Taser Bigfoot. About 1 year later, she actually comes up with a $350 filing fee and sues Phil Poling individually in federal court on a copyright violation. The lawsuit action is for copyright infringement and defamation. Hovey contends the following facts. In late 2008, she formed the American Bigfoot Society. In late February of 2012, she secured the exclusive rights and privileges in and to the copyright of a photograph known as the 2012 Bigfoot photo. The certificate of registration is included as an exhibit in the case. Hovey is listed as the author and that the author created a photograph. The certificate is in her name, not the American Bigfoot Society. The actual photographer's name or location are not mentioned. She also contends that Phil Poling posted material online, both written and video, containing false statements about Hovey, including but not limited to Hovey stealing money, stealing the material relating to the copyrighted photo, used the photo for monetary gain rather than research, released video for the purposes of fame rather than professionalism, was an amateur, and filed false claims under Digital Copyright Act and received funds for participating in conferences. She contends that the above act caused damage to Hovey's business and reputation. She has since had to close memberships to her organization, received threats from members of the community, and suffered emotional distress. The 4 counts she brings against Poling are, first, copyright infringement. Hovey has suffered and continues to suffer damages. Second, defamation. Hovey suffered special harm from the material Poling posted. Defamation, per se. Hovey suffered from Poling's words as it injured her trade or occupation. Conversion. Poling used Hovey's property and she was damaged by that action. What Hovey wants. A preliminary injunction to end Poling's action. Relief from the court finding Poling has engaged in copyright infringement, defamation, and conversion. And the big ones, damages, cost of the action, and reasonable attorney's fees for the copyright infringement, defamation, 2 counts, and conversion. Damage award sought is in excess of $75,000. Well, that was just the start of the facts, folks. Mr. Poling received notice of the court filing and immediately obtained counsel. I'm sure that it was not the response that Hovey was looking for, but that's what was happened, and no one can blame him. A few weeks later, Poling's legal team presented their answer to the court, and these were their responses. Phil Poling admits to publishing the photo and then pretty much denies or has no knowledge of the rest of Hovey's assertions. One particular denial is that Hovey had no lawful right or interest in the photo. Her registration is not valid and cannot be enforced. He, by counsel, also identifies 8 affirmative defenses and uses some of Hovey's own postings to her blog and other words in support. These are to include Melissa Hovey allowed the use of the photograph freely for non-profit and educational purposes, which is what Mr. Poling did. The photograph is of a costume and is incorrectly characterized by Hovey as a live Bigfoot. Hovey fails to state a claim upon which relief can be granted. Hovey has failed to join the necessary parties, meaning the owner of the photograph. Hovey's claims are barred because of unclean hands as a result of her own misconduct and wrongdoing. Hovey's actions or inactions amount to the waiver of her claims, and Hovey violates the Ohio Revised Code prohibiting frivolous conduct in civil actions. At this point in the case, evidence was presented to the court with blog posts, webcasts, as well as appearances where Melissa Hovey admits she does not own the picture. She did not take the picture. She doesn't really know who took the picture, nor does she really know who owns the picture. Phil Poling also files a counterclaim on Melissa Hovey's actions that those details are as follows. Melissa Hovey has falsely and fraudulently claimed copyright ownership. He references 2 exhibits of Hovey's own words and deeds, asserting that she has widely and publicly admitted that she has falsely claimed and registered her claim to copyright to the photograph. She falsely and fraudulently swore a claim to the federal court that she is the lawful owner. Hovey has so lawful interest, but has admittedly usurped this right from the owner and others who independently possess copies of the photograph. Hovey allowed others to use the photograph, but singled out Mr. Poling for litigation. Her copyright and other claims are abject failures, and this was known by Hovey and counsel prior to their effecting service of the complaint. Now, because of the false and fraudulent claim, Poling seeks legal fees and costs of at least $25,000. Defamation. Hovey has repeatedly, with malice, called Mr. Poling a liar and a thief in public. Frivolous conduct. Hovey brought this action with the express purpose of harassing Mr. Poling with this frivolous action. Further, the expressed purpose of this action to extort a settlement. Hovey's claims are not warranted and cannot be supported with good faith argument of existing law, and it violates Ohio code which prohibits frivolous conduct. Poling again asks for the $25,000 for his cost, expenses, and attorney's fees for defending Hovey's claim, and for that it can be shown reasonably accounted for and shown to the court. So no, Phil did not attempt to collect anything more than the cost of his attorneys that were sizable at that point, and already a long drawn-out court case ahead of it could have reached $100,000 in legal fees alone. Well, it seems that the last release in this case is finally over. Hovey versus Poling dismissed with prejudice on August 17th, 2013, as posted on the Bigfootery Inquirer. And with prejudice is important. It indicates misconduct on the part of the claimant and forbids her from filing another claim. A settlement agreement was brokered by the magistrate, and the stipulations include, first, that both parties are responsible for their own costs and attorney's fees. Second, removal of and cease further disparaging of defamation remarks toward each other. Third, Hovey must file within 20 days at her own expense a disclaimer and forfeiture of her registration of her claim to the copyright in the photograph. What does it all mean? It's pretty simple. Melissa Hovey has failed in her attempt to sue Phil Poling, as she never had a claim to the photograph in the first place. She was forced to remove her copyright claim. So it all boils down to a person that felt entitled to inflict financial hardship on a person out of pure vengeance and harassment over a fake Bigfoot picture of a man in a costume, which, by the way, is actually owned by Carl Kozak, the director of the feature film Claude. Yep, that's the one that we all said it came from well over a year ago. I have many opinions on the matter, but for now, I'm just happy releasing the facts of the case. Yes, it's a little biased, and I'm rather shocked that no one out there has even covered any of this lawsuit to date, barring the good people over at the Bigfootery Inquirer. Hovey got a fake picture owned by someone else, filed a fraudulent copyright on it, released it, and then sued someone for using the picture in a way she didn't like. Failed miserably in her efforts, save for causing significant financial hardship and damage to a man that had no fault whatsoever. What do you do with a person who has exhibited such horrible decision-making and belligerent disregard for the law and the community? I can think of several other persons that acted just as poorly, and they're now a pariah to even mention their name. I'm sure this will make many out there unhappy that these things are coming to light, but I, for one, just can't let it pass quietly into the night. It could have been me, or you, or just about anyone else Melissa Hovey didn't like. I'm sure this isn't the last we'll hear on this case, as the tales will be spun, yet you can count on me to bring the truth to light. If anyone in the Hovey camp would like to debate the actions taken in this case, feel free to contact me, and I'll be glad to host you on my podcast, and we can discuss the matter in a civil way, and let's just see where the chips fall. Thanks for joining me for the Fringe News number 54. I'm Reverend Jeff, and may the Squatch be with you.